Yeah, good afternoon and welcome to our viewers, but most particular to Professor Sands. And it's very good to see you with us today. And some time ago, I participated in a partly staged reading of East-West Street here in The Hague, together with the well-known German actor Katja Riemann. It was impressive to see how you made the works of Ravel, Prokofiev, and Bach meet Lauterbach, Lemkin, and a war criminal like Hans Frank. And I was deeply touched by the way in which you described how these crimes affected your own family. While I saw you for the first time on stage in The Hague, many of our viewers today know you from other aspects of your incredibly rich professional work. They know you from the Great Hall of Justice in the Peace Palace, where you appear regularly in many high-profile proceedings. They also know you from Courtroom 600, the site of the Nuremberg trials, where you attended last year the 57th anniversary of the opening of the Nuremberg trials. And they know you from the covers and the content of many, many books, both academic and for a larger audience, as I just mentioned, East-West Street and The Red Line being fascinating examples of narrative history. Dear Professor, you seem to be a person whose day has more than 24 hours, and we wonder how you can do all of that, and whose urge to inform the world about the importance of law and the difference between good and evil is inexhaustible. Decades ago, this battle between good and evil was exclusively attributed to the horrors mankind inflicts upon each other. In reaction, human rights law and international criminal law were developed in order to strengthen the good and to fight the evil. While this fight is far from over, you, Professor Sands, and many others now argue that another aspect has come up. Not only do we need to protect our fellow humans, we also have to protect our environment, our climate, our planet. Why? Well, to put it bluntly, without a habitable planet, there are no more human beings whose rights could be protected. We have seen in this city and elsewhere many rulings in the past weeks and months related to the issue of protection of the environment. And so we see a debate in full swing. And we know that you and others have made proposals just 2 days ago on how that debate could become more concrete. And I think apart from the concept, we would be very interested also in learning a little bit what was the driver, what was your personal motive to go from genocide to ecocide and do even more than 24 hours. And with this, Professor, I would like to give the floor to you in a moment, but first encourage our viewers to ask questions in the chat function for the questions and answers part later. They can start doing that at any time. I expect there to be many questions, so our main job here will be to try to pick a good balance of questions, which we will then put to you. Professor, dear Philip, the floor is yours.
Ambassador, thank you so much for your kind words and also for inviting me. It really is a pleasure for me to be here as part of a series of events to mark your contribution to diplomatic life in The Hague and in the Netherlands. The Hague, of course, is a very important city for many of us. It's the world center for international justice with a number of international courts and tribunals. It's a place I love to come. I haven't been, of course, because of the difficult circumstances for some time. I miss it terribly. I miss my favorite cafe, Clarence, where I will always go at 7:30 every morning before every hearing I'm at to have a coffee and a fresh squeezed orange juice. I love that city, and it's become a very important place for me. You are right that 2 days ago, there was publicly announced the product of an effort by a group of 12 lawyers, an international working group, charged with exploring the possibility of coming up with a definition of a potential new crime, a fifth international crime, the crime of ecocide, to join the 4 others that were in place from 1945 and new interests. And I'll say something in due course about that definition that we came up with. I was very privileged to co-chair with a very distinguished jurist from Senegal, Dior Fall, and we had a very varied group, which is always, I think, more interesting. It wasn't a group of like-minded people, and so we engaged in a very real debate. But I was very pleased that we came up, 12 of us, despite our very different backgrounds, with a consensus document. And I'll say a little bit more about that. And, President Scheinmeier in courtroom 600 on this extraordinary occasion. And at that moment, I did think to myself, could my grandfather have ever imagined 75 or 80 years' time from the circumstances that befell him and his family, I would be there warmly in the spirit of friendship in which reconciliation has absolutely been achieved, talking about the future. And I saluted to the president of Germany, Germany's absolutely leading role right now in promoting international criminal law. It has become absolutely the flag bearer for liberal democracy and the idea of the rule of law in international relations. And I see that at the domestic level, some of the prosecutions that are taking place with your federal prosecutor, Peter Frank, who I've come to know, prosecuting some of the worst crimes in Syria and Iraq, playing a real leadership role. And I'm proud to be associated with those efforts. My own story of coming here is a sort of roundabout way. Life is unexpected. In the mid-1980s, I was a very young academic when the Chernobyl accident happened on the 26th of April, 1986. I was teaching. I was a junior to my mentor, Elie Lauterpacht, the son of Hersch Lauterpacht. And Elie said to me, oh, this thing is interesting. Why don't you do a paper on the legal aspects of Chernobyl? And it was fascinating. Back in 1986, there was no such thing as international environmental law. I wrote a paper for a conference in Washington, D.C., and I then went to the IAEA, where I was retained by the delegation of Greenpeace as their legal advisor. And I spent 2 years working with Hans Blix and Mohammed El Baradei when they were respectively the Director General and legal advisor. And I came to see for the first time how international law was made. And that then led to my founding an NGO, a legal NGO, the Center for International Environmental Law, still exists today, based in Washington, D.C. I'm not associated with it, but I warmly commend the work that they do. And writing one of the first textbooks on international environmental law, which was published by Cambridge University Press. And the very first contentious case that I got involved in the Hague Court at the International Court of Justice was the case of Gabčíkovo-Nagymaros, the barrage dispute between Hungary and Slovakia. And I was brought into that case. I want to take an opportunity, because there are many colleagues in Holland and in The Hague, I think probably watching this, to just pay a tribute to my dear late friend, James Crawford. There was no lawyer I was closest to. He introduced me to many things. We did dozens of international cases together on opposite sides, on the same side. He became a judge at the International Court. Very sadly, he passed away 2 weeks ago. I was in a sense prepared for his departure, but nothing can prepare you. He was an extraordinary human being who made an extraordinary contribution, including in the field of international environmental law. From the environment, I then moved by accident. Actually, it was through a case I did with James. First case I ever did at the International Court of Justice, the advisory opinion on the legality of the use of nuclear weapons, a request from the General Assembly of the United Nations. And I was charged with making the argument that somehow the use of nuclear weapons could impact negatively on the environment, and this would raise legal issues. And the then British Attorney General responded directly to my arguments, saying that Professor Crawford was speaking nonsense, and Mr. Sands, as I then was speaking dangerous nonsense on all this environmental stuff. But of course, things have changed since then. I did those cases on nuclear weapons for a group of small island states from the Pacific. I'd worked with them a year earlier on a case brought by New Zealand on the testing by France of nuclear weapons, underground this time, announced by President Chirac. And the Pacific Small Island States then asked me in 1997, having worked with them on climate change, negotiations of the Framework Convention, whether I'd be willing to attend a conference in Rome in the summer of 1998 to draft something that would be called the International Criminal Court Statute. And it was a fascinating project. I was in Rome. I worked very closely with my dear friend Andrew Clapham, professor at the Graduate Institute in Geneva. And we were charged, in fact, with writing the preamble. And no one amazingly paid very much attention to the preamble. And so we put a few things in it which we thought would be taken out, but never were taken out. But it developed in me an appetite, an interest in international criminal law, the different direction from the environment. But I've then spent quite a lot of time in the last few years working on a whole range of cases. It was a significant year, 1998, because there were important secret indictments at the Yugoslav tribunal, President Milosevic of Serbia, but also, as you will recall, in October of that year, Senator Pinochet of Chile was arrested in London. People forget that his arrest was premised on a warrant for crimes against humanity and genocide. I then got involved in a peripheral way in those proceedings and have been involved in many cases since, most recently, as you will know, as we talked about it, the proceedings brought by the Gambia against Myanmar in respect of allegations of genocide at the in relation to the Rohingya community. Those proceedings were very special in many ways, not least for finding myself standing about 3 meters from Aung San Suu Kyi, who defended the interests of Myanmar at in that case. So there was a sort of coming together of these two sets of issues. And of course, there was then an important intervening event, you've touched on it, for me personally, which was that in 2010, I received an invitation from an obscure university that frankly I had never heard of, the Ivan Franko University in Lviv. Would I come to Ukraine and Lviv and talk about the cases that I had done on crimes against humanity and genocide? And I accepted, not, to be very frank, because I had a burning desire to give a lecture on international law, but because I somehow worked out that Lviv was also Lvov, Leopolis, and Lemberg. And Lemberg was where my grandfather was born in 1904. And I thought, well, that's interesting. He never talked to me about Lemberg. It would be wonderful to go to Lemberg and find the house where he was born. It was a sort of quest for identity, actually. I wanted to know more about my grandfather, because in knowing about him, Leon Buchholz, nice Germanic name, I would learn more about myself. And I spent the summer of 2010, as you know, you've read East West Street, you've seen the performance, exploring the origins of genocide and crimes against humanity, and was staggered, literally, to accidentally discover, I mean, I don't think I can take any real credit for it. I can't say that I had a thesis and I had a hunch. Total accident that the man who invented the concept of genocide, Raphael Lemkin, and the man who put the concept of crimes against humanity into the Nuremberg Charter, Hirsch Lauterpacht, both were students at that law faculty. It was astonishing when I turned up. They were amazed that the road to crimes against humanity and genocide led to the very room in which I gave a lecture, because that was where they had been lectured between 1915 and 1926. Life is very amazing. And the book, as you know, explores their lives, Lauterpacht, Lemkin, my grandfather, Leon Buchholz, but also Hans Frank, a fascinating character, very serious lawyer, a very fine mind, very cultured man, but who had accepted to be appointed Governor General of German-occupied Poland from October 1939 and got involved in many ghastly things, along with his deputy, Otto Wächter, an Austrian, who is the subject of the sequel to East West Street, which is called The Rat Line, or in Germany, Die Rattenlinie. So all of that's by way of context. I was contacted in the autumn of 2020 by Jojo Mehta of Stop Ecocide, who had worked with a very interesting English barrister, Polly Higgins, who had for many years, in relative obscurity until her work began to bear fruit, for the idea that the growing set of rules on the environment should be extended to the criminal law, and that there should be a new international crime of ecocide. And her work was premised on what had happened in 1998 in Rome. There was an idea of including in the Rome Statute a crime dealing with environmental harm. It was felt that it sticks 4 crimes. War crimes, the oldest, the 19th century crimes, the crime of aggression as it is today, crimes against peace as it was in Nuremberg, crimes against humanity, and genocide. And that was the decision. Indeed, the idea of ecocide goes back even further. You can trace it to a speech given by the Swedish Prime Minister, Olof Palme, at the famous 1972 United Nations Conference on the Human Environment in Stockholm, where really international environmental law truly the seeds, the roots took place there. So there was a history that came along. Polly Higgins sadly did not see her work to come to fruition. She passed away a couple of years ago, and I think it's in her spirit and to her memory that we take that work forward. Jojo Mehta got in touch. Would I be interested in co-chairing with Dior Fal a working group to explore the possibility of a text that would allow the environment to be the subject of a 5th crime, the crime of ecocide, a melding, if you like, of some of the principles from the crime of genocide and crimes against humanity. And I didn't really have any hesitation in doing it for a number of reasons. Firstly, intellectually, it was challenging because interesting work had been done by Polly and by others. I think of Richard Falk, the distinguished American jurist, former professor from Princeton, and Ben Whitaker and various other characters who have addressed this issue. And I thought, well, perhaps I can be inspired by the story of Lauterpacht and Lemkin. Remarkably, these inventions, and people don't realize the crimes against humanity and genocide were invented as legal terms, could provide a basis for learning as to how we might now deal with environmental issues. My own background, working on environmental issues for 15 years from the mid-1980s, of course, was significant. But the other thing that I noticed was that there was a generational interest. A couple of British newspapers reported on this initiative, and I have 3 children. They sort of follow, and they're of course very supportive of the things that I get up to, but like normal children in their teens or in their 20s, they don't think a lot of what their parents do is pretty useless or uninteresting. But this was the first time when it was announced that I and others would be involved in this issue, that each of them got in touch. I got a WhatsApp or a text message from each of them saying, Dad, that's fantastic. You're finally doing something that's really useful. And that sort of, I think, connected with the zeitgeist. We all have the sense that something is going on, whether it's climate change or biodiversity or a whole raft of other environmental challenge. The cases that you've been referring to, the agenda case in the Dutch courts, and a more recent case involving Shell, and there is a global rise of case law seeking to harness the power of the law alongside diplomacy and politics and economics and social media to achieve a greater degree of environmental protection. And then I think also COVID has, in a sense, reminded us of the limits of human autonomy, the extent of our vulnerabilities, and the extent to which we are connected with each other. We can't sort these things out on our own. We need to work together. And so, yes, a very interesting group of 12 has spent 6 months coming up with a definition. We didn't start from a blank slate. Many people on this call will be aware that, for example, in 1977, as long ago as that, states agreed that the use of environment as a weapon of war would be outlawed. And they came up with definitions which provided a basis. And in carrying out our work, we were able to base ourselves in many different elements of existing international law. Ambassador, you're well aware, as I am, that states are very conservative creatures. And an idea has a greater prospect of getting off the ground if it has roots in something that has come before. I'm acutely aware of this when I make arguments before international courts. And so we all agreed that we needed to base what we had done on what came before. I'm going to read to you, I won't take you through the whole text, maybe in the questions we can have a further discussion, but I'll give you the definition that we've come up with. For the purposes of this statute, ecocide means unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. I'll just make a few brief points about that relatively simple and straightforward text, which is based on precedent. There has to be severe damage to the environment, and we define damage and we define severe damage also. That's a first threshold. The second threshold is that it must be either widespread in a geographic sense, or it must be long-term in a temporal sense, as a way of limiting what could come before the jurisdiction in the future, possibly of the International Criminal Court. But we were also concerned to make sure that there be a third threshold. We're all acutely aware that many human acts, including ones which I'm involved in, contribute to harm. So there has to be a third threshold, and that is that the act has to have been either unlawful by reference to domestic law or international law, or it has to be committed in a wanton manner. And wanton is really, I think, the key to it. An act that is undertaken with reckless disregard for the damage which would occur and which would be clearly excessive in relation to any social and economic benefits anticipated. So it's those three thresholds that we've put in place. And we've been balancing in a sense. On the one hand, we wanted to come up with something which could be practical in relation to the egregious acts that ought to be covered. But on the other hand, we didn't want to come up with something which would frighten states away and make them feel that basically much of daily human activity would somehow be caught. And where you set that threshold is a complex issue, and reasonable people can disagree about where you set the threshold. Within our group, we had at one end of the spectrum individuals associated with activism in various parts of the world who were very committed to a low threshold. At the other end of the bar, we had a former judge of the International Criminal Court, a former US federal prosecutor who had been a prosecutor at the ICC, reminding us of the practicalities. And I think, judging by the reaction over the last 2 or 3 days, we've struck the balance about right. Of course, reasonable people will agree or disagree with elements and aspects, and no doubt there will be discussion. What happens next? Well, it may just die a death and be kicked, as we say in London, into the long grass, or if a small group of states, 5 or 6, feel that this has legs, they will decide to run with it. And if they decide to run with it, they will go to the Assembly of State Parties and they will say, it is time for us to reflect on the possibility of a 5th crime. And they will no doubt come up with their own ideas, or maybe this idea or variations of this idea. And they will have to persuade ultimately the Assembly of State Parties and 2/3 of the state parties, it's about 80 countries, to adopt a text. So I'm not starry-eyed about the prospect, but I have a hunch that the zeitgeist may be right, that this might be the right sort of timing to begin a process of elaboration of such an idea. And I'm strengthened in that sense by the fact that we did have, a week before we launched publicly the definition, a private session for a group of interested states. We imagined it was just going to be 6 or 7 to start with, but in fact 14 turned up, and we had a very interesting session with very well-placed people, very knowledgeable people who asked very good questions. And I got the sense from that, interestingly, that the interest was geographically quite broad. As you know, there's support for this idea at various national levels. Right now, there's a lot of debate in France. President Macron has called for a crime of ecocide. Bangladesh, elsewhere in the world, is extremely interested in this. And it may well be that the idea gets off the ground. And once the idea is off the ground, over time, I suspect there'll be no stopping it. So it'll be very interesting to see what happens. Let me just finish by saying one thing. People who know me know I am not starry-eyed about international law. I'm acutely aware that the invention of concepts like genocide and crimes against humanity did not stop horrors from occurring, and they have not stopped genocides or crimes against humanity from occurring. And I have no illusions that the mere adoption of a draft or indeed a binding definition of a crime of ecocide will suddenly make states behave in different ways or change things. But I do think the main lesson I have from my deep dive into 1945 is that the concepts of crimes against humanity and genocide, newly invented in 1945, changed human consciousness. They drew a line and said, certain things are permissible and other things are not permissible. And I think that's my hope for the crime of ecocide, that if it takes off, the most useful function it can perform is to encourage us all to recognize that the protection of the environment is an end in itself. It's not just about protecting humans, and it is a socially useful thing to be done, and the law can play a role in that. Let me conclude with a brief anecdote linking all of this together. In November 2019, I was in Washington at a seminar at George Washington University, invited by my former student, actually, and dear friend Sean Murphy, Professor Sean Murphy, and other colleagues, on the work I'd done on crimes against humanity and genocide. And I shared the panel with a very good friend of mine who many people in this audience will know, Thomas Bergenthal, who had been the American judge at the International Court of Justice for a number of years. I appeared before him on several occasions, including in one allegation of genocide case where he found firmly against me, I should say. And Tom Bergenthal is a remarkable man, an academic, but as a little boy, he was at Auschwitz, and he was under the care of Joseph Mengele in 1944. He wrote an extraordinary book about it called A Lucky Child, and I commend that book to all of you. And on the panel, we were talking about the upcoming hearings in The Hague beginning in December 2019, which you'll remember, Ambassador, when the Gambia had an application for provisional measures against Myanmar. And it was based on the 1948 Convention on the Prevention and Punishment of Genocide, which had been adopted really at the instance of the idea of Raphael Lemkin and the work of Raphael Lemkin, who did not just curl up in a corner and weep in the summer of 1945 when he learned what had happened to his family. He channeled his intellect and his energies into coming up with a new crime, genocide. And Tom Bergenthal said to me, can you imagine, Philippe, if in 1944 there had been a crime of genocide, or there had been an international court to which states or others could go, in which a faraway country could have said to Germany, actually, you can't do this. This is not permissible behavior. And that's, I think, what inspires me. We are facing a real challenge with the environment, and we can sit back and say it's too complicated, it's too difficult. Or in our various areas, like Lemkin, we can play with the ideas of others, of Polly Higgins and James Crawford, and try to give them flesh, persuade our governments to run with them, and try to change the world in this modest way, but nevertheless open the door to future change at a later stage. That was the spirit in which our working group worked, and I thank you hugely for giving me an opportunity to talk about this.
And as I was expecting, a very good explanation, and also, if I may say so, a very personal touch. You referred to Lemberg, and I think the area of Galicia, Galicien, as we say in German, has always been, so to say, a very hotbed of European culture where so many things came together in the past. With respect to what we are hearing now, you referred to the issue of agreed language. I can share that sensation. I was negotiating communiques in an international organization. I know agreed language is always something diplomats like a lot. You're very true on that. Maybe a few questions, one from our side and from the audience, which we already picked up. As I said before we got started, we have seen one reaction already before your speech from one person saying, why are you trying to put that into the statutes area, so to say? You know that states may be conservative, as you said yourself. Why are you not trying another avenue? That was one question I got. Another one is, so to say, on the term, actually, because ecocide obviously alludes to genocide, but the letter, however, includes a subjective requirement of intent to destroy a specific group. So we wonder, such intent is not included in your definition of ecocide, but you mentioned wanton. So is this wanton part coming close to that or issue of intent? Then we have another one, or we have not just one other one. When do you think ecocide will be enshrined in international law, and when we will have court cases? So this is the look into the future. Another one is actually reaching a topic which is very important these days. Would zoonotic disease spread like COVID be covered by that definition? So that is a special one. We have yet another one, which is, does ecocide have potential to evolve into an avenue of corporate accountability in international law? I think that's going very much to the heart of the matter also. And how, and here I will stop because I don't want to overreach. How will this work with law of the Sea Convention and, for instance, deep seabed mining? So how will this work with law of the Sea Convention and deep seabed mining?
Gosh,
so that
gosh, it's like
I think that is good enough.
It's like doing a Viva and a PhD, I would say. These are fantastic questions. And they
yeah, you know, and it is even a free lunch because we are virtual.
What excellent questions. I'm not surprised there are so many questions. All of the questions are so good. You know, we did an event with the media on Tuesday when it was launched, and it was astonishing. 750 journalists signed up, and there were 125 questions in 40 minutes. I mean, I do a lot of, you know, Zoom type things. I've never experienced something like that before. So let me go quickly through each of these questions. Why the statute? Well, this could be done at the national legal level. We've seen difficulties with that in France immediately. It could be done by an international convention, but we've seen that the ILC draft on crimes against humanity has frankly got stuck in New York at the United Nations, and there doesn't seem to be much of an appetite for going in that direction. The beauty of the ICC statute is it provides a natural focus for criminal law, and it provides a means through the amendment procedure which is identifiable and which is doable in relatively straightforward terms given the membership. One of the attractions of the ICC statute is that once you've become a party to it, you have an obligation to implement into your domestic law all of the crimes. So it will be a short circuit way, if it were to be adopted, of transforming national law in many countries. When the United Kingdom, for example, became a party to the Rome Statute, it had to incorporate the crimes of genocide and crimes against humanity in domestic law, which didn't previously exist. So that, I think, makes the explanation. The term ecocide does indeed evoke the concept of genocide, but we have not gone with the genocide definition. The genocide definition, as you rightly say, is an intention to destroy a group in whole or in part. And frankly, if we were to take a definition of the intention to destroy the environment in whole or in part, there would never be a crime, because basically no one intends to do that. What people intend to do is exploit natural resources or engage in activity which has the inadvertent consequence of causing damage. So you had to come up with a crime which effectively carries the definitional aspects that are more analogous to crimes against humanity, but which reflect Lemkin's term. Why? Very interestingly, the Stop Ecocide Foundation did some research with public opinion on different formulations. And what I was told was that if you referred to an environmental crime against humanity, it was a big yawn, no one paid any interest, no one knew what that was. But the moment you said to people in the street, ecocide, the reaction was, oh yes, yes, we're against that, that's a terrible thing. They understood what it was. And it reflects the magic or the difficulty and dangers of Lemkin's word. If an American president points to a place on earth and says, there's a genocide taking place there, it's on the front page of every newspaper in the world. But if an American president says there's a crime against humanity or war crimes going on in that place, no one pays any attention. The media doesn't cover it. There is something in the word Lemkin invented that opens the imagination and attracts attention. So what we've effectively come up with is a definition which uses the cloak of the term genocide, but the innards are more akin to crimes against humanity. We thought about amending crimes against humanity to include as a crime against humanity damage to the environment. And the reason that doesn't work or didn't work for us was that we didn't want to make the crime of ecocide limited to impacts on human beings, which is what crimes against humanity is about, the well-being of individual human beings rather than groups like genocide. And for that reason, we concluded it had to be a standalone if you wanted to emphasize not an anthropocentric approach, because of course the impact of environmental harm on humans is significant, but also to say the environment is worth protecting in its own right. You don't have to show harm to humans to show the crime of ecocide. Of course, if there is harm to humans, that could be a contributing factor, but it's not a necessary prerequisite. The term wanton goes, of course, to elements of the mens rea, but we haven't dealt with intent. The way we've dealt with it is more akin to crimes against humanity, acts committed with the knowledge that there's a substantial likelihood of severe damage. In other words, it's a sort of recklessness standard. If you engage in an act and turn your eye away from the consequences, you are potentially exposing yourself. But we have not gone with the definition, the mens rea of intent, because I don't think it would ever apply. When will it be enshrined? With respect, Ambassador, that's a question for you and your government and many other governments. That's not in my power. I express the firm hope, not that the government of Germany and other governments will say, oh yes, we support this as a definition, but that they won't reject the idea that the time has come to reflect on it. What I'm looking for are statements by foreign ministers or presidents or prime ministers or environment ministers saying, you know what, this is an interesting idea, let's think about it, let's explore it. That's, for me, would be a very positive sign. It could be done, if states want, relatively quickly, by which I mean 3 to 5 years, or it could be done relatively slowly, by which I mean 50 years. You know, Lemkin invented his word in 1944. He was bitterly disappointed that the Nuremberg judgment, we're about to celebrate the 75th anniversary on the 1st of October, makes no reference to the concept of genocide. And people forget that none of the defendants were convicted of genocide. The Americans were opposed to the term because they worried about how it would be used in the southern states and in relation to Native Americans. And so it took years, frankly, at the international level for the concept of genocide to take off, 50 years, although there were prosecutions in national courts in the Soviet Union, in Germany, and in Poland in the period after the war. So it's going to be your call, Ambassador. I'd say somewhere between 5 and 50 years before it's on the statute books, and then it will be a matter for prosecutors and judges to determine whether a circumstance arises. Could it cover COVID? I don't think so, because the definition of the environment is on impacts on the environment. Although you could say that as human beings, as a species, are part of the environment, that too could be covered. But I must confess that wasn't really what we had in mind. But, you know, wiser folk will no doubt reflect on this and go much further. Corporate accountability, it's very important to stress that the statute of the International Criminal Court gives the judges jurisdiction only over individual human beings, not over associations or NGOs, not against corporations, not against governments. But of course, governments, corporations, associations, NGOs are run by individuals. And so there is no reason why individuals, a chief executive or chief operating officer, or a prime minister or a president, or the head of an NGO type association could, because of their actions, be caught. So corporate accountability is not directly envisaged, but the individuals who are responsible for running the corporations could certainly be caught. You know, I've been very surprised by the media interest level, but also the sources. A lot of financial journalists very interested, and I did an interview with one leading journalist from a leading international financial newspaper, and in the interview she said, well, could it cover the chief executive of ExxonMobil if he authorizes, you know, drilling and exploration on a scale that is considered to be harmful? To which my answer was, well, I don't want to mention particular individuals or particular activities. We chose purposely not to list particular activities, because once you have a list, you leave out certain things which certain people think should be included, but also you put the emphasis on certain things which are rather complex, including climate change and loss of biodiversity. How will it affect the law of the sea convention? Our definition of the environment includes the hydrosphere, and so it could certainly include damage to the deep sea bed. That is not excluded, but of course you'd have to meet all of the conditions. These are wonderful questions, I have to say, and I'm very pleased to have them and any more you want to throw my way.
Yes, and the next one actually kind of links up to the one you touched upon immediately before, which is, would terraforming space bodies like other planets be included in Ecocide? Difficult one. And how to define victims of ecocide in cases of diffuse damage. For example, in terms of light for reparation issues. So that is two questions we got, and I will get another one in a moment, but let's have these two.
Outer space we did include, yep, that is, and it's included in various international conventions. One of the things I should stress is that I can point with every reference in our definition, in our main definitional paragraph, and in all the sub-definitions, to existing language or text on which it is based in existing international law. And that was very important for me personally and for many members of the group, because we didn't want to be accused of making things up on the hoof, and because we wanted to be able to point to precedents and authorities. So yeah, I read in my newspaper this morning that a couple of countries have a joint project to set up a new permanent station on the moon. Well, you know, yes, in principle, if they do that in a way that is harmful to the lunar environment, in principle, yes, that could be caught. Now, diffuse damage is really a fascinating question. I would say not only diffuse damage, but I'm going to broaden it to diffuse sources of harm. Climate change. Obviously, climate change activities are envisaged, harmful activities are envisaged within the definition, but frankly, it's a difficult one to see precisely how it's going to operate. Every single one of us as human beings contribute to climate change. Does that make each of us criminals? Well, in the eyes of some, yes, it does, but not in my eyes, because some activity that contributes to climate change is obviously necessary for human existence and necessary for human well-being. The question becomes, how do you draw a line that a particular act has crossed to say that is not permissible? And of course, the examples that others have raised include the authorization of a massive new oil field, the authorization of a new massive coal mine, the destruction of forest or rainforest on a very large scale, the destruction of other sinks of greenhouse gases. International law, in fact, is already reasonably sophisticated. And the notion of joint and several liability, which applies also in the criminal context and in the statute of the International Criminal Court, would no doubt come to our aid and our assistance. But I have to accept that these are issues that will emerge in the wash, so to speak. We can't foresee every single possibility. Every situation or case is going to be fact dependent. At some point in the future, a prosecutor is going to have to decide whether there is a colorable case to be argued. And that prosecutor, she, he, they are going to have to persuade 3 judges at the International Criminal Court that prima facie there is grounds for investigation. And then the prosecutor is going to have to come back to those judges and persuade them to issue indictments. So in that process of reflection, the prosecutors and the judges, and no doubt the states parties to the statute, will be reflecting on all of these issues. I'll give one example of how the law changes through the process of interpretation and application. And that is in the crime of genocide, as originally conceived by Raphael Lemkin, there is no reference to sexual crimes. Rape, for example, was not included in his definition, and it's not included in the 1948 Convention. But in 1998, the Rwanda Tribunal in The Hague, under the auspices really of a single judge, Navi Pillay of South Africa, interpreted the definition of genocide to encompass the use of rape on a systematic basis as amounting to a crime of genocide. And that, some people would say that's a judicial legislation, judicial activism. Others would say, no, the law has to be interpreted by reference to our value system as it evolves over time. And that's the way, I think, in which the International Criminal Court will proceed over time.
Thank you. Another set of issues was related to the question of if we would have such a definition in the statute, what would it mean for the people implementing, for lawyers, for prosecutors, judges, but also state representatives? How can we make sure that people would actually be equipped in a way that they could implement what you foresee in your plans? And the next set of questions, could ecocide, I'm just reading, lead to broad understanding of ICC territorial jurisdiction, giving the Myanmar decision, in case danger caused applies globally, so thus also within state parties? And then wanton means disregard for damage, that is, for instance, excessive in relation to economic benefits. Would that exclude destruction of rainforest, which gives economic benefit? The last one, I think, is a very virulent one.
No, these are really terrific questions, if I may say. And of course, I'm able to at least address them. I can't say answer them, but address them because we've been talking about these things for months. let me talk about what would it mean for people on the ground. Well, you know, I remember the first time I stood before the International Court of Justice and made an argument about the environment. It was in 1995. So not so long ago, but still quite a long time ago. And I was counsel for Solomon Islands before the International Court of Justice on the case concerning legality of the use of nuclear weapons. And I made the argument that the environment was affected or would be affected by a use of nuclear weapons, and that had legal consequences. And I remember very well looking at the faces of the judges, and you could tell, you know when you're in court, when you've got the interest of the judges, and you know when you've lost the judges, or some of them. And I could tell with some of the judges, I know which ones they were, I remember which ones they were, just looking at me like I was a crazy person. What is this environment nonsense? But interestingly, in the advisory opinion at paragraph 29, for the first time in its history, the court said, no, the protection of the environment is part of international law. The contrary view held by a small minority of judges who put in dissenting statements did not prevail. And I think the question about what do we do to prepare is an important one, because there is a change of consciousness which is generational. The people who taught me international law, wonderful teachers, Robert Jennings, Ellie Lauterpack, did not grow up in a time of environmental consciousness, so they were not aware of it. Even I never had a course at university on the protection of the environment in international law. I teach that course now at my university in London and elsewhere. So the generation of students that are now becoming lawyers will be aware of it. But I have the sense that the current and emerging generations are aware of it. I'll just say one further thing. I want to respect the Chatham House rule, but let me just say I'm involved in an interesting initiative with various people at the Red Cross in Geneva. And nothing to do with this, nothing to do with Ecocide. But in a recent conversation with some of them, they mentioned that they were very interested in this. And I was very surprised by what they said. They said, the Red Cross has now firmly endorsed the protection of the environment, not just in times of war, but also in times of peace. And I wasn't aware of that. They are going through training that the environment is part of the issues that their own lawyers now have to think about. And so I think that issue will be addressed over time. Territorial jurisdiction, well, there we certainly have an interesting issue. We have it in the Myanmar-Bangladesh case. Myanmar is not a party to the statute of the ICC. Bangladesh is, and 3 judges in their wisdom have recently ruled, a couple of years ago, that the court has apparently jurisdiction in relation to the inability of Rohingya refugees to return to Myanmar because that part of the crime could be said to be being committed on the territory of a state party. And we have, of course, exactly the same thing in relation to Israel-Palestine. Even more controversial. Israel says it's not a party to the statute, and therefore it cannot, and its nationals cannot be subject to the jurisdiction of the court. No, ruled a 3-panel preliminary chamber of the ICC earlier this year. That's not right. If you engage in an activity on the territory of a party to the statute, you expose yourself to the risk. And equally, if the territory of Palestine, whether it's a state or not a state, I'm not expressing a view on that, is used to launch rockets into the state of Israel, the fact that Israel is not a party to the statute does not preclude the ICC from exercising jurisdiction because the rockets are launched from land which is subject to the jurisdiction of the ICC statute. I'm just going to raise it as a question. Can we imagine the outcry when an act that takes place with environmental consequences that are negative is initiated on the territory of one state that is not a party to the statute of the ICC, but is felt on the territory of a state party? the logic is, on the decisions that you've mentioned, and the one that I've mentioned, that the ICC would appear to have jurisdiction. But of course, the environment, even more than war and rockets and military invasions and torture, is by almost definition transboundary in consequence. And it will be for the judges, I think, ultimately to determine that absolutely significant issue. The third question, again, we debated this at length, and I will be frank, some members of the group, a small number, did not like the cost balancing exercise. But I can tell you, we drew that from an existing provision of the ICC statute, where there is a cost benefit analysis in relation to the definition of certain war crimes and crimes against humanity, whether the military advantage outweighs, if you like, other negative aspects. And it was the way we saw to allow judges in the future to form a determination as to the reasonableness of whether or not harmful environmental activity would nevertheless be considered to be not criminal within the statute, because it brought clear and significant human, social, economic benefits. And I think it will be a matter there for the judges, or the elements of crimes that will have to be developed if this is ever to pass, to develop the basis on which this crucial issue is addressed. And I can quite see that one person, if asked the question, is the destruction of the Amazon rainforest today the crime of ecocide, will say, no, it's not, because of the economic advantages. And another would say, yes, it is, because in no way can the purported economic advantages outweigh the negative environmental consequences. And that's not a debate that our group was able to resolve. Our task was to come up with the tools to think about the issue, and ultimately it'll be decided on a case-by-case basis. Great question, though. Great questions.
But you could understand this, since definition is based on recklessness or dolus eventualis. Why did you choose knowledge? That was one. Related to that, will states accept the crime of ecocide with the mens rea of recklessness, dolus eventualis? More specific one, no?
Ambassador, your guess on the second question is as good as mine. What will states want to do? Who knows what states will want to do? I mean, my sense is that some states will want to do something. And they will turn their minds, as is happening now in certain places. I'm following the debate within France. And they're realizing there are levels of complexity to this, and one needs to proceed with deliberation and with care. Ultimately, states will decide where to set the threshold. You know, when Raphael Lemkin came up with his definition in 1944, it was very different from the one that eventually emerged in 1948. Well, very different. It was different. It was not the same. And it evolved. And essentially, states decided to set the bar higher than Lemkin wanted to do. And ultimately, we have to respect the fact that our legislature in the international arena is one comprised of states. And it will be for them to decide where they want to set the bar, if they want to open this door. I think we've set the bar in a reasonable place, but others will say it's too high or it is too low. And we will see in due course what happens. In terms of the mental element, we focused on knowledge because we foresaw that that was the most appropriate standard drawn from the existing statute for the crime that we had in mind. We rejected intention for the reasons that I've already explained. But knowledge in the practice of international criminal law includes the failure to turn your mind to something you should have turned your mind to. In other words, it's not a defense to say it never occurred to me that this would cause particular harm. You have a positive duty to inquire and inform yourselves whether your acts are likely to, for example, impact upon civilian targets. You can't just say, I never thought about it. And it's going to be the same, I suspect, in relation to the environment. It won't be to a defense to say, I just never thought about it, or I couldn't have imagined it. So knowledge is not, if you like, in the ordinary day-to-day sense, but in the legal sense that has emerged in the context of international criminal law.
Thank you very much. And we did go a little further than the 1 hour which we had planned, but I think that was worthwhile doing. I think we had a very good session in terms of your introduction, but also a very lively debate in terms of the Q&A. I hope the questions were challenging enough. I must excuse myself to those in the audience whose questions we were not able to capture, but we tried to have a good mix of questions here. You kind of contributed to a debate which is started and which I think will keep us busy for a long time to come, not just us here in The Hague, the international law community, or us, the states, but more than that, academia, the civil society, NGOs, etc. I think this will be one of the topics we will be discussing for quite some time to come because it is an urgent debate. And with this, I would like to thank you, Philippe. Very grateful for your contribution to this debate. I thank the audience and I thank my colleagues for setting this up. And then hasta la vista.
Hasta la vista. And I join in warm thanks to the audience and to you and to all your staff at your embassy. And I wish you well in wherever you end up next.
Thank you and see you soon.
Thank you.